JJTP A Lawyer, not your lawyer, back for part 2 of my response. This time, let's talk about the laws and rules regarding class action lawsuits. Again, this video was not on my docket, it's a response video, so it won't be as polished as my other videos, but let me see if I can get you some quick information. The case that was being discussed in the original exchange was Ross v. Lockheed Martin. The case citation is 276 F sub 3rd 174, D.C. Circuit 2017. I'll post in the comments. In the original video, the poster claimed that Judge Jackson Brown did not support the black employees of Lockheed Martin in a class action lawsuit. He fails to understand the rules and laws governing class action lawsuits, specifically Federal Rule of Civil Procedure 23A. 23A sets out the prerequisites for certifying a class in a class action lawsuit. First, the class has to be so large that joinder is impractical. Second, the whole class have to share common questions of law and fact. Remember that one. That one will be important. Third, the class representatives have to have claims and defenses that are typical of the class. Finally, there has to be fair and adequate representation to protect all the interests of the class. Judge Jackson Brown's ruling is 52 pages, way longer than it takes up, so I'll put the link in the comments and summarize here. In essence, Judge Jackson Brown held that there was not commonality of all the proposed members of the class. Remember, that's the second requirement in Rule 23A. What this means in English is that all parties weren't equally damaged, and therefore we can't use the same measure of damages, as that wouldn't be fair to all parties. Let me quote from the case on page 51.
Moreover, the broad release of legal claims in the proposed settlement agreement strongly suggests that the parties have endeavored to use this case to resolve the entire universe of race discrimination claims that these class members might have against Lockheed, via a lawsuit that is purportedly much more limited in scope. This imbalance creates serious fairness concerns with the breadth of the release, the adequacy of the settlement fund, the prescribed opt-out procedures, and the overall claims administration process.
In essence, Judge Jackson Brown is protecting all the black employees from a bad settlement that will have only benefited a few, while stopping all the rest from recovering from any damages they suffered. Pulling back the curtain for some inside baseball. The reason why lawyers push for settlements in these class actions is because we get the majority of the money. Then, the named plaintiffs get a little bit more, but in general, the actual class members get pennies on the dollar at best. Back to the regular programming. The original poster claimed that this was unheard of. However, any real lawyer would know not only is this commonplace, but it's required under the law, Rule 23, as we saw. Contrary to their statement, this is not a simple settlement. This is a class action, and all parties must be given a fair opportunity to opt in, opt out, and object to the settlement. But we didn't even get that far, because the class wasn't even certified. Contrary to what the original post would have you believe, Judge Jackson Brown did the right thing. She followed the law and the regulations, and the criticism is unwarranted. Let me know if any of this is unclear, or if you want me to do a follow-up with an actual video about class actions. Until next time, like and sub. Note from the lawyers, this video is based on the laws at the time of taping this video. It does not constitute legal advice. You should always consult with your own attorney before taking any action, with the exception of liking and subbing so you can hear more legal facts like